welcome to the deep dive. For anyone really putting their creative work out there or building a business, understanding intellectual property is, well, it's crucial. It's not just legal stuff.
No, absolutely. It's about protecting what you've made, the value in it. Think of it as the framework for innovation, for branding.
Right. And today, we're planning to cut through some of that complexity.
We are. We're using a really interesting source today. It's a guide from Together SC, looking at the kind of questions you'd ask an IP lawyer in an interview. It gives us a great practical angle.
Yeah, using their questions as our guide. I like that. So let's dive in. First big one, the core differences, right? Copyright, trademark, patent. They sound similar sometimes, but they're really not.
Not at all. They protect fundamentally different things. So, copyright, that's your protection for original creative works.
Creative works? Like what, exactly?
Well, think books, music, paintings, photos, even software code, architectural drawings, anything where there's original authorship fixed in some kind of tangible form.
Tangible form, meaning you can see it, read it, hear it.
Exactly. It gives the creator control over copying, distributing, making adaptations, performing it publicly, that sort of thing.
Okay, so my blog post, that song I wrote, copyright. Makes sense. What about trademarks then?
Trademarks are all about the brand. It's what helps customers identify your products or services and distinguish them from competitors.
Ah, so logos, brand names.
Yes, logos, names, slogans, sometimes even sounds or colors if they function as a source identifier. Think of, famous brand symbols. They tell you where something came from.
Got it, standing out. And the last one, patents. That's invention territory, right?
Precisely. Patents protect inventions, new machines, processes, chemical compounds, even improvements on existing inventions. There are different types, like utility patents for how something works and design patents for how something looks.
And the idea there is to give the inventor a kind of monopoly for a while.
Essentially, yes. For a limited time, the patent holder gets exclusive rights to make, use, sell, and import the invention. It's meant to encourage innovation by offering that period of exclusivity.
Okay, let's try to tie that together. Quick example. I invent a new kind of solar panel.
Right.
The technology, how it works, that could be patented.
Potentially, yes, if it meets the requirements for novelty, non-obviousness, and utility.
Then I call it the SunSpark panel and give it a cool logo. That's trademark.
That's trademark territory, protecting the brand name and the logo.
And maybe I write a detailed installation guide.
And that guide, the written text, and any diagrams would be covered by copyright.
Okay, I think I see how they fit their own specific niches. That helps.
It does. Each one is a distinct tool in the IP toolkit.
Now let's get practical. Question 2 from the guide. Sort of. What if a client loves a brand name, but it sounds a bit like one that's already out there? How does an IP lawyer handle that? That seems like a common problem.
Oh, it's very common. And this is where proactive legal advice is key. The first absolutely essential step is a thorough trademark search.
Not just checking the official database.
No, much more than that. You check federal databases, state databases, but also common law sources, basically, how names are being used in the marketplace, even if not registered. You're looking for potential conflicts.
And the goal is to assess this likelihood of confusion thing.
Exactly that. That's the legal standard. Would a typical consumer be likely to be confused about the source of the goods or services because the marks are similar?
What goes into that? Just how the names sound.
Sound is one factor, definitely, but also appearance, meaning the overall commercial impression.
Yeah.
Critically, you also look at the relatedness of the goods or services.
Right, like using a similar name for a car versus a computer might be okay, but maybe not for two types of software.
Potentially. The more related the goods or services, the higher the risk of confusion.
Yeah.
You also look at trade channels. Where are they sold? Who are the customers?
So if the search comes back looking risky, what's the advice? Just pick a new name.
Often, yes. That's usually the safest, most cost-effective advice. It avoids potential opposition during the registration process, or worse, an infringement lawsuit later. Better to choose a stronger, more distinctive mark from the start.
But are there other options? What if the client really loves the name?
Well, depending on the specifics, sometimes you might explore a coexistence agreement.
A coexistence agreement. What's that?
It's basically a contract between the two trademark owners. They agree on how they can both use their similar marks without hopefully confusing consumers.
So they carve out rules, like you stick to this region, I'll stick to that one. Or you sell clothing, I'll sell electronics.
Exactly. Things like geographical limitations, differences in the types of goods or services, maybe modifications to the marks themselves. It requires careful negotiation, but can sometimes allow both brands to operate.
Interesting. A way to manage the risk, maybe, instead of just avoiding it entirely. Okay, let's shift gears a bit. The guide also mentions infringement cases. Can you walk us through, like, a hypothetical but realistic example, maybe involving software?
Sure, software is a really complex area for IP, especially patents. So imagine a scenario. A smaller tech company launches a new software product. Then they get a letter from a larger competitor claiming the new product infringes on several of their software patents.
Ouch. That sounds serious. What's the defending lawyer's first move? Panic.
Haha, no, hopefully not panic. The first move is deep analysis. You have to meticulously examine the patents being asserted, specifically the patent claims.
The claims. Those are the legally binding parts.
Precisely. They define the boundaries of the invention protected by the patent.
Yeah.
The lawyer compares the accused software, feature by feature, function by function, against those specific claims. Does the software actually perform all the steps or contain all the elements laid out in a particular claim?
So it's about that exact match, or lack thereof.
Largely, yes. That's the non-infringement argument. But there's another angle. Validity.
Meaning challenging the patent itself.
Exactly. The lawyer investigates whether the patent should have been granted in the first place. Maybe there was prior art, earlier inventions, publications, products that showed the same invention existed before the patent was filed, or made it obvious.
Ah, so digging into the history.
Right. If you can find strong prior art, you can argue the patent is invalid and therefore unenforceable. So the defense strategy might be twofold. Argue, we don't infringe your claims, and/or your patent claims are invalid anyway.
Wow. So it's highly technical, requires understanding the software and the patent law intricacies.
Absolutely. It demands both technical literacy and sharp legal strategy.
Which brings up another point from the guide: this field changes so fast. New tech, new laws. How do IP lawyers even keep up?
That's a constant challenge and a critical part of the job. You simply have to be committed to ongoing learning. IP law is definitely not static.
So what does that look like? Reading legal news all day?
Well, that's part of it. Staying on top of court decisions, new legislation. But it's more than that. Lawyers read specialized journals, attend CLE continuing legal education seminars focused on IP updates.
Conferences too, I bet.
Definitely. Industry conferences, legal conferences, they're vital for understanding new trends, emerging technologies, like AI's impact on copyright, for instance, and networking with other experts. Participating in professional organizations, like IP sections of bar associations, is also key for staying connected and informed.
It sounds like you really have to be plugged into both the legal world and the tech or creative world your clients operate in.
You absolutely do. You can't advise effectively otherwise.
Okay, let's consider another tricky situation. What about when a lawyer has clients whose interests might clash? Not directly representing opposing sides, but maybe in the same industry with competing IP. How do you handle that ethically?
That requires very careful navigation. Let's take a fashion industry example. Say a lawyer represents a designer who gets accused by another designer of copying a specific dress design.
Okay, so your client is the accused one.
Right. Your primary duty is to defend your client zealously, but you also have to consider the whole picture, the accuser's potential rights, the cost of fighting, the business relationship, maybe.
So it's not just about winning in court at all costs.
Often, no. Especially in industries where relationships matter. The goal might be to find a resolution that protects the client's immediate business needs while acknowledging the other party's claims, if they have merit. It's a balancing act.
Could that involve something like the coexistence agreement we talked about with trademarks? Or something similar?
It could lead to something like a licensing agreement. Maybe the accused designer pays a royalty to the original designer to continue selling the dress, perhaps with some modifications or limitations.
Ah, a negotiated solution.
Exactly. It acknowledges the potential IP right, but allows the business to continue, avoiding a potentially damaging and expensive court battle. It's about problem solving, finding that middle ground where possible, always within ethical bounds, and prioritizing the client's best interests.
That makes sense. Finding a pragmatic path. Okay, one last big area going global. Protecting IP isn't just a domestic issue anymore. How does a lawyer advise a client who wants to sell their patented gadget or use their trademark overseas?
That has a whole other level of complexity, for sure. The fundamental thing to understand is that IP rights are territorial.
Territorial, meaning a U.S. patent only counts in the U.S.
Correct. A patent granted by the USPTO doesn't stop someone in Germany or Brazil from making or selling the same thing in Germany or Brazil. Same goes for trademarks. A U.S. registration doesn't automatically protect you elsewhere.
So you need protection country by country or region by region.
Essentially, yes. You need a strategy for each market the client wants to enter. The first step is understanding their business goals. Where are they planning to manufacture, sell, license?
And then researching foreign laws.
Exactly. The lawyer needs to research the specific IP laws in each target country. What are the filing requirements? What's patentable or trademarkable there? What are the enforcement mechanisms like? This often means collaborating with local counsel, lawyers who specialize in IP in that specific country.
Wow. Coordinating with lawyers all over the world.
It's often necessary. Then you develop a filing strategy where to file first, leveraging international treaties like the Patent Cooperation Treaty or the Madrid Protocol for trademarks where possible to streamline the process, but ultimately deciding which specific countries warrant the investment in seeking protection. It's very strategic.
So it's a bespoke plan for each client's international ambitions.
Absolutely. No one-size-fits-all solution when it comes to global IP. It requires careful planning and often significant investment.
This has been incredibly insightful. We've really covered a lot of ground based on those interview questions. Differentiating copyright, trademark, patent.
Tackling potential trademark conflicts, looking at how infringement cases play out.
Yeah. And the need to constantly learn, balancing interests, and then this whole global dimension.
And the hope is that this gives you, the listener, a clearer, more practical grasp of these concepts. IP really underpins so much of our modern economy, innovation, creativity.
It really does. So here's a final thought for you listening.
Yeah.
Considering these different types of IP, copyright, trademark, patent, what's one place you encounter intellectual property in your daily life that maybe before today you didn't really think about in those terms? It could be anything.
That's a good question to ponder. It's often hidden in plain sight.
It really is. Give that some thought. Thanks for joining us on this deep dive.